Order in the court. Okay, welcome everyone. I'm Michael Zuma. I'm the president of the Long Island chapter of the Federalist Society. And tonight we have a very interesting program with two very well-qualified, very, I guess you call them experts in constitutional law, who have opposing views on this issue, I understand, which makes it more interesting. So we're going to start our debate. First, I wanted to welcome all of you newcomers, tell you a little bit about the Federalist Society. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application to its activities. And if anyone would like to actually become a dues-paying member, I do have brochures. I just put them there instead of putting them on the tables because I get tired of walking around and then I pick them all up. So they're all over there. There's also a sign-in sheet over there where if you don't have, if you're not getting emails from the national office, put your email on there and we'll try and get you on their email list. There was one brochure, I guess it's gone, there's a James Madison Club, if anyone is so inclined. It's $1,000 a year. They were always looking for those people, but I think someone grabbed it, so I guess they want to make that contribution. Okay, to moderate our debate and to actually introduce our speakers is Frank Scaturo, and I will introduce Frank. Frank's a longtime member of the Federalist Society. He's an attorney and author. He's currently a partner at FSB Fisher Broyles, LLP, a leading national law firm. From 2006 to 2009, Frank served as counsel for the Constitution on the United States Senate Judiciary Committee. Frank has taught at Hofstra Law School, where he was a visiting professor during the 2009 to 2010 academic year. Last year, he was a Republican candidate for the U.S. House of Representatives in New York's 4th Congressional District. In addition to several articles he has written in the areas of American history and law, he is the author of President Grant Reconsidered, published by University Press of America in 1998, and The Supreme Court's Retreat from Reconstruction, a distortion of constitutional jurisprudence, published by Greenwood Press in 2000. He's also the co-author of Public Companies, published in 2002 by Law Journal Press. Frank is the founder and president of the Grant Monument Association, which spearheaded the restoration of President Ulysses S. Grant's tomb during the 1990s. Frank is a graduate of Columbia University and the University of Pennsylvania Law School. And Frank will take over. My sinuses are not great, so I think maybe we'll do better with him introducing the rest of our panel. Thank you.
Well, thanks so much, Mike. Thank you all for being here. We have a really special panel set up tonight with two of the finest, most distinguished minds in the country, in my humble opinion. Having had the opportunity to work in Washington myself, I can tell you that there are very few people that you will find of the caliber of both Hans von Spakovsky and Jim Poe. Both have been guests of this organization before, and we're so glad that both of them could come back. Just by way of an introduction, Hans von Spakovsky has a wide range of experience in election-related issues. He's a 1984 graduate of Vanderbilt University School of Law. He received a Bachelor of Science from MIT in 1981. He's vice chairman of a county board that's responsible for administering elections in Fairfax County, the largest county in Virginia. Formerly served as a member of the Fulton County Registration and Election Board in Georgia. He served as a member of the first board of advisors of the U.S. Election Assistance Commission, which advised the commissioners on the administration of the Help America Vote Act. He served as counsel to the Assistant Attorney General for Civil Rights of the Department of Justice from 2002 to 2005, where he provided expertise and advice on voting and election issues, including enforcement of the Voting Rights Act and the Help America Vote Act of 2002. He was commissioner in 2006 to 2007 of the Federal Election Commission. It was there that he was responsible for enforcing federal campaign finance laws for all congressional and presidential elections, including the Presidential Public Funding Program, and remains to this day one of the preeminent commentators on this field of law. He currently serves in the Heritage Foundation as a senior legal fellow and manager of the Civil Justice Reform Initiative in the Center for Legal and Judicial Studies, where he concentrates on the issues of voting, elections, campaign finance, civil justice and tort reform, civil rights, and government reform. You've probably seen Hans's work at a wide range of places, including articles in the Wall Street Journal, the Washington Times, National Review Online, and Human Events, to name just a few print venues, and then you may have seen him on Fox News and CNN, not to mention numerous other shows. We're really privileged to have him with us. James Ho is James Ho is currently a partner in the Dallas office of Gibson, Dunn & Crutcher, LLP. He originally graduated from Stanford University with honors and a BA in public policy, and graduated from the University of Chicago Law School with high honors. He has over a decade of government experience, most recently as Solicitor General of Texas, the state's chief appellate lawyer and U.S. Supreme Court litigator. As Solicitor General of Texas, Mr. Ho litigated and counseled state officials on some of the most difficult legal issues facing the state. Appointed by Attorney General Greg Abbott, he is the first Asian American to serve as the state's chief appellate lawyer. Mr. Ho has argued and won cases in diverse areas of law at courts across the country. He has the highest win rate in the U.S. Supreme Court of any Texas Solicitor General, and a 22-2 record as lead appellate or trial counsel in other federal and state courts. Jim has also served in all three branches of the federal government. On Capitol Hill, he served as chief counsel to Senator John Cornyn and to the Senate Judiciary Subcommittees on the Constitution and Immigration. At the Justice Department, he was the second highest political appointee at the Civil Rights Division. He also worked at the Office of Legal Counsel, advising the White House and other senior officials on constitutional and other complex legal issues. In addition, he served previously as a law clerk for Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit and Justice Clarence Thomas of the U.S. Supreme Court. Before law school, he was a legislative aide to State Senator Quentin Kopp. Mr. Ho has also taught U.S. Supreme Court litigation as an adjunct professor of law at the University of Texas Law School. He's a frequent commentator on national issues and an active member of numerous national and statewide organizations. And I can't forget, it was a great loss to the Senate Judiciary Committee when Jim went to go clerk for Justice Thomas. This was while we were still in the process of considering the nomination of Chief Justice Roberts. C. Boyden Gray came to give our committee a pep talk, and he said, as he looked around the room, you know what we really need to get this guy confirmed? We need a Jim Ho. And we didn't have him, but we were able to get by anyway. That's not to overlook what a fine public servant he has been, and I'm sure will continue to be. The very, very bright future ahead. So please join me in welcoming Jim.
I think that we decided we're going to go for it. I think I want to go for it.
You guys flipped the coin, or what did you do?
Basically, so you decided that Hans will go first. The debate tonight, the subject of the debate is whether children of illegal aliens, undocumented persons, born on U.S. soil are in fact U.S. citizens under the Constitution. Of course, there are policy dimensions to this issue, and while the commentators may want to weigh in on that, the central issue that we expect the discussion to focus on will be whether the Constitution compels an answer in one direction or the other. So we'll start with Hans.
Thanks. Well, I appreciate the invitation to come back. So I guess I must not have done too bad last time.
Actually, you had one of the highest turnouts of any of our recent events, so you did us proud.
Nice. And I don't know if Frank will get you in trouble if people know that we used to conspire together when he was still in Washington, working up in the Senate. And James, I don't know if it will make you go any easier on me if I tell you that the guy who appointed you to be Solicitor General, Greg Abbott, was actually a classmate in Boston. Oh, it's all right. A couple of months ago, maybe six months now, there was quite a bit of controversy in Washington because some senators, I think starting with Lindsey Graham, said, well, we really need to amend the 14th Amendment of the Constitution to get rid of birthright citizenship. Now, the argument I want to make to you in my 15 minutes is that actually no amendment is necessary because the original text, legislative history of the 14th Amendment is such that the senators and people who put that amendment together never ever contemplated that it would be interpreted the way it's been interpreted, basically by executive fiat by the State Department, to require that the children of people who are here illegally are U.S. citizens. Now, what does the 14th Amendment say? The 14th Amendment says that all persons born in the U.S. and subject to its jurisdiction thereof will be citizens of the United States. Now, you all may remember, the 14th Amendment was passed after the end of the American Civil War. What was the purpose? It was to make sure that slaves, former slaves, and their children were considered citizens of the United States. And it actually was intended to constitutionalize and validate a civil rights statute that Congress had passed in 1866. It was the Civil Rights Act of 1866, which basically said that, quote, all persons born in the U.S., United States, comma, and not subject to any foreign powers, close quote, would be citizens. Now, you notice there's a little bit of a change of language. All persons born in the U.S., not subject to its jurisdiction, that's what the 14th Amendment says, will be U.S. citizens. Now, what does that mean? Now, the whole reason I got into this, and
that's subject to its jurisdiction. Not subject.
Not subject to its jurisdiction. Yeah. The whole reason I got into this was because I got home late from work one night, and I turned on the TV, and Bill O'Reilly was on Fox News, and he was debating this very issue. And he got it completely wrong. And I thought, you know, I really need to write something about this, try to explain it. And I did, and I sent it to Fox News, and they published it. I don't know if Bill O'Reilly ever read it and corrected himself. But the issue came up when the 14th Amendment was being written and was being debated over whether, for example, this meant that American Indians who were not U.S. citizens, even though they were born in the United States, would this mean that they would be made citizens? The person who came up with the phrasing for the amendment, who was Senator Jacob Howard of Ohio, specifically, he was the author of the Citizenship Clause. He said, Indians born within the limits of the U.S. and who maintain their tribal relations are not, in the sense of this amendment, born subject to the jurisdiction of the United States. Further, Senator Lyman Trumbull, who was the chairman of the Senate Judiciary Committee, agreed. He said that the phrase subject to jurisdiction thereof meant, quote, not owing allegiance to anybody else, subject to the complete jurisdiction of the U.S. The mistake that Bill O'Reilly was making on his show was he was saying, well, subject to jurisdiction of the U.S. Well, let anybody here who's in the U.S., whether they're a tourist or here illegally, is subject to our laws. You know, they break the law, they end up in our courts, they go to court. That is not what they meant when they were discussing this. They weren't talking about territorial jurisdiction, because of course a tourist who's here on a visa can't simply break our laws and go back to his country and get away with it. What they were talking about was the very phrase that he just used, not only anyone else. And that's why, in fact, American Indians were not considered citizens of the United States. Why? Because at the time they were born, they owed an allegiance to their tribal governments. And in fact, if what proponents of birthright citizenship say is true, then there would have been no reason whatsoever for Congress in 1924 to pass the federal law which finally made Indians citizens of the United States. Now, if you think about that for a second, too, realize this. If you're talking about American Indians who were born in the United States versus, for example, someone who is here who is actually a citizen of another country, whose children, when they are born in the U.S., are actually citizens of another country, tourists, who has actually more of a claim on the idea of being a U.S. citizen? Well, it's American Indians, right?
Well, no.
And yet Congress considered that they were not citizens of the United States under that language. Now, in the Slaughterhouse case of 1872, it's a very famous case, the Supreme Court in dicta said this. They said that this phrase was intended to exclude, quote, children of ministers, consuls, and citizens or subjects of foreign states born within the United States. That would apply to any children of illegal aliens. Why? Because in the same way that my wife was born in the Manila, Philippines. Why? Because her father worked for B.F. Goodrich and was there working for the company, right? She was born in Manila Hospital. Well, of course, she's a citizen of the United States because her parents are citizens of the United States. So she, in the same way that children who are born here of illegal aliens owe an allegiance to a foreign government, children of illegal aliens is the very same thing. There was a case in 1884 called Elk versus Wilkins, in which the Supreme Court basically adopted what had just been dicta in the Slaughterhouse cases. This was a case of an American Indian who had been born on a reservation. He left the reservation, forswore allegiance to his tribal government, and then sued the United States when he couldn't become a citizen. And the Supreme Court said that he could not become a citizen because at that time, 1884, he, quote, owed immediate allegiance to his tribe and not the United States. That's why it took a federal act in 1924 to make American Indians citizens. Now, the case that everybody who's a proponent of this relies on is another case called U.S. versus Wong Kim Park, 1898. Chief opinion written by Justice Gray. Now, in that case, the court held that the child of Chinese immigrants who were permanent residents of the United States would be considered a United States citizen. But you got to remember a couple of things. One, first of all, you know, at the time we had very discriminatory laws, and at that time, even though these Chinese citizens were permanent residents of the United States, they could not become U.S. citizens. Why? Because we barred Chinese from becoming citizens, something that is, of course, long gone.
Well, that was required by a relation with the emperor, who would have regarded it as sort of an act of war.
That's true, but the point is that the court actually kind of ignored the prior decisions of the Supreme Court and made them citizens. There was very broad language issued by Judge Gray, and he basically had a completely wrong view of the establishment of the 14th Amendment and the American, related to the American Revolution. In fact, under Judge Gray's view, let me see if I can find this quote here for you. He said in his opinion, quote, "A stranger born, for so long as he continues within the dominions of a foreign government, owes obedience to the laws of that government and may be punished for treason. In other words, he thought that this was so broad that if a tourist came here from Germany and committed an act against the American government, he could be charged with treason. Now, of course, a German who comes here on a tourist visa could be charged with espionage for doing something against the United States. But the idea that you could charge a citizen of another country with treason to the United States when they're here is ridiculous. And that shows, quite frankly, why some of the language that he adopted is wrong. The other basic problem, and then I'll stop. It should take about 5 minutes. Right. Is this. If you look back at the American Revolution, and you look back at the debates over the 14th Amendment, what is this whole country based on? It's based on the idea of the consent of the governed, correct? And that is one of our most fundamental beliefs. The idea of birthright citizenship was something that came from English common law. And in fact, the person who expressed it was probably, the greatest British lawyer of all time and the greatest commentator on the common law, Blackstone, who all the lawyers in here have heard of. And what did Blackstone say? Well, Blackstone said that the idea of birthright citizenship came from what? The feudal system. Because he believed that natural allegiance is due from all men born within the king's dominion immediately upon their birth. It is a debt of gratitude which cannot be forfeited, canceled, or altered by any change. In other words, if you were born a British citizen, you could never not be a British citizen, which is one of the causes of what? The American Revolution. Because the king and the monarchy said, you are British subjects, you will always be British subjects. And we said, no, our rights come from natural law. We have natural rights as citizens. And in fact, the whole idea of birthright citizenship, the way Blackstone expressed it, was completely rejected by the Frankers. And in fact, Thomas Jefferson, in 1774, in the Summary Review of the Rights of British Citizenship, said that not only do we reject birthright citizenship, but we recognize the idea that an individual can choose to leave his country at any time and go to another country and become a citizen of it, something that the British did not recognize. And in fact, in 1868, almost the same time as the 14th Amendment, Congress passed the Expatriation Act, which provided that the right of expatriation is a natural and inherent right of all people. In other words, they recognize in federal law this right that we have and others have to leave the countries they are in and to go somewhere else to become a citizen. And you cannot reconcile the right of expatriation with the idea of birthright citizenship. Also, remember, we're a government based on the consent of the government. That means not only that we as individuals have to consent. So someone who comes here has to make the choice to consent to become a citizen. But they have to have the consent of the community also. And it's very clear to me that the 14th Amendment did not give citizenship to individuals when our laws don't provide for that. That's not within the consent of the governed. And we don't have the kind of reciprocal consent that require that. My argument is really all based on the Constitution, but I will tell you this from a policy standpoint. What was the budget deficit in New York have been dealing with last year? How much? How many billion?
New York, about 11 billion.
8 billion, right. Okay, well the last estimate that I found from DHS, Department of Homeland Security, 2007, they estimated there were 640,000 illegal aliens in New York. FAIR, which is an immigration group in Washington, estimated that there were 1 million illegal aliens in New York. 11.7% of the children in schools in New York, K through 12, are students, are children of illegal aliens. The cost to all of you to pay for that is $4.3 billion. The total cost of illegal aliens estimate that I found is $5.1 billion a year. Most of that is for education. And by the way, that education estimate does not include programs for limited English students and things like that. Healthcare costs you almost $700 million for unreimbursed healthcare costs. Incarceration of illegal aliens costs you around $165 million. That cost does not include the costs of law enforcement and judicial expenditures. And by the way, those costs don't include the amount that you're paying for welfare. Now, most people will tell you, no. Illegal aliens don't get welfare because federal law, immigration law, when it was amended, said you can't get welfare if you're an illegal alien. That's true. But illegal aliens get huge amounts of welfare benefits. Why? Because they get benefits through their children. Okay, so the costs to you are very large, and the cost per household headed by native-born citizens is around $874 to pay for all. So from a policy standpoint, I don't think it's a good idea. From a constitutional standpoint, I don't think it's required. And by the way, we are one of the very few countries in the world that recognizes birthright citizenship. The few countries that have had it have mostly gotten rid of it, and nobody in Europe recognizes it. Thanks.
Thanks, Hans. Jim?
First of all, let me start by saying how grateful I am for the Federal Society, the Long Island chapter, in putting on this forum. I actually think that the Federal Society is, in many ways, the perfect venue to discuss this constitutional legal issue. Federal Society members, as we all know, have really actually a surprising diversity of views when it comes to policy and philosophical issues. But if there's one thing that I think tends to unite society members, it's the fundamental commitment to the principle that there is a difference between what the Constitution, what we might want the Constitution to say, and what it actually does say. The appreciation that there's law and politics, and one should not infect the other. And it just so happens that this is an issue that, in terms of the constitutional issue, the interpretation of this document itself divides Federal Society members on the issue before us. Let me start my presentation with a bit of a confession. I don't think I need to tell anybody that when it comes to immigration, illegal immigration, immigration reform, all the various policy and political debates that we see across the country, in Washington, Arizona, elsewhere on immigration, it's hard to imagine a policy debate that generates more heat, more emotion, you might even say more anger, than this issue of immigration. And so my confession is this. It's sort of surprising to me that despite all that anger and emotion and the energy, I actually find myself kind of surprisingly ambivalent when it comes to a lot of these immigration tough policy reform issues. And that's, I think, because, on the one hand, I'm an immigrant myself, and as an immigrant, I've always felt that one essential attribute of American exceptionalism, or what makes America truly unique and special in this world, is the fact that we are, in many ways, a nation of immigrants. On the other hand, I'm also a lawyer. And as a lawyer, I have a profound commitment to the rule of law. And therefore, anybody who has a commitment to the rule of law is naturally concerned about the issue of illegal immigration and the profound challenges that illegal immigration presents to the rule of law. So I'm ambivalent about a lot of these discussions. And if we're speaking purely, if I'm speaking sort of in my capacity as a citizen, I have, frankly, mixed emotions, mixed feelings about some of these debates that we're seeing. But speaking as a lawyer, I actually have very firm views on the issue we're debating here today, this issue of birthright citizenship. And in fact, I believe that when it comes to this issue of birthright citizenship, the American values in support of immigration and the rule of law actually point in precisely the same direction. Now, just to set the table, and we've already gotten a good presentation here, but just to set the table, many conservatives believe that we should repeal citizenship for children born in the United States to non-citizens, particularly the undocumented, but there are some proposals that are broader and reach all non-citizens. Many conservatives believe that we should repeal this. And they believe that repeal is actually an essential component of any comprehensive proposal to enforce immigration. And indeed, for years, I've actually been saying that this is an effort that is a serious one, that deserves attention. Members of Congress have been supporting this cause for many years. It's more on the conservative side, although I'll note that Senator Harry Reid, obviously now the Democratic Majority Leader, Senator Reid actually proposed this many years ago himself. But today it's predominantly more of a conservative Republican proposal. Members of Congress have done this. Conservative legal scholars across the country have published articles supporting repeal. And actually no less a jurist than Richard Posner, obviously one of the most renowned federal courts of appeals judges in the country. He has come out saying that Congress should just repeal this by statute. So I've been sort of talking about this issue for a while, but this year, 2011, is actually turning out to potentially be a very special year on this issue, perhaps a blockbuster year on the issue of birthright citizenship. The very first week of this year, a group of state legislators actually convened in Washington and announced a concerted multi-state strategy to repeal birthright citizenship as a matter of state law. And then this Congress, as Hans noted, a number of not only members of the House, but now a group of U.S. senators have come out to support birthright citizenship repeal by statute. So this is a very serious, robust effort. But just because there are a lot of loud voices and distinguished jurists and scholars coming out in support of this doesn't mean that they're right. And in fact, I would submit they're badly wrong. And in fact, I would submit that the proposal to repeal birthright citizenship by statute actually violates three values that are commonly espoused by conservatives. The values of textualism, originalism, and American exceptionalism. I'll try to take these in turn quickly. To begin with, I would submit that these proposals violate the very first sentence of the 14th Amendment. And Hans read it earlier, but let me read it again since it's so critical to our discussion. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That's what the text provides. I would submit that the meaning of this text is actually quite straightforward. What does jurisdiction mean? Jurisdiction means power. For example, when we look at Article 3 of our Constitution, it uses the word jurisdiction to describe the judicial power of the United States. The jurisdiction of a federal court is the power of the federal court. And I would submit that that term is likewise used in the 14th Amendment to invoke the power of the United States government. So I think the rule of the 14th Amendment is rather quite simple. If you are born in the United States and subject to the power of the United States, you're guaranteed citizenship. Now, of course, this phrase, subject to the jurisdiction, it's got to mean something, right? We're not going to violate the agent canon against surplusage and just read it out of the provision. I think some people who take the other side of this issue accuse folks on my side of just reading it out of the Constitution, which is absolutely not true. We acknowledge, at least I acknowledge, that this phrase means something. It's got to exclude somebody from the protection of birthright citizenship, and it does. It does. The Citizenship Clause denies birthright citizenship to persons who are not subject to the power of the United States government, who have some basis for legal immunity from the United States. It excludes, for example, diplomats who enjoy diplomatic immunity under the international laws of diplomacy. It excludes lawful combatants who enjoy immunity against our laws under the laws of war. It also excludes members of Indian tribes due to the unique legal issues presented by the issue of tribal sovereignty. But the clause covers everybody else. This is not just, by the way, what the text provides. It's also what the sponsors of the Citizenship Clause said they intended. It's also why the opponents of the Citizenship Clause said they opposed it. And it's also the same rule that we get from the English common law doctrine of jus soli, on which the 14th Amendment was based. The legislative history, and Hans mentioned the legislative history, really most of the debate on this issue comes down to competing interpretations of the legislative history, so I'm going to spend a little bit of time on this. The legislative history, I think, a best fair reading of the entire history on this really confirms two things. It confirms that there was a congressional consensus on 2 points. One, that the Citizenship Clause would cover the U.S.-born children of foreign nationals, like the Chinese, which was a special topic of discussion during this debate. And there was also congressional consensus that this language would not cover, would exclude Indian tribes. I'll take the history very quickly. The House passes the 14th Amendment, and it passes the 14th Amendment that does not have any of this language. So it goes over to the Senate, and it's in the Senate where this language is offered for the first time. It's Senator Howard of Michigan stands up, introduces this language as an amendment to the 14th Amendment, and he explains what he's trying to do. He wants to provide, consistent with the natural law, the common law jus soli doctrine, protection of U.S. birthright citizenship if you're born in the United States. And he says, look, it's not going to cover diplomats. He specifically talks about diplomats, ambassadors, it won't cover them, but it'll cover everybody else. Okay, so he presents it, offers it for discussion. That triggers a rather heated response from Senator Cohen of Pennsylvania, who says, I would want to specifically point out the discussion about allegiance, the talk about allegiance in legislative history. I have a very different view of legislative history here. Senator Cohen specifically condemns the citizenship clause because he says this is crazy. This is crazy because this language would give U.S. citizenship to people born to people in the United States who have no allegiance whatsoever to the United States. This is his interpretation. He says it's a terrible idea, and he would vote against the proposal precisely for that reason. That triggers a response from Senator Conness of California, who says, I completely agree with Senator Cohen that that's what this language would do. It would cover people who have never expressed any allegiance to the United States. I just happen to agree with that. I think we should extend protections, for example, to the Chinese laborers who were in his state of California. So in short, there was actually a remarkable consensus in Congress about the meaning of the citizenship clause. The dispute was simply over the wisdom of this provision. And of course, we know more 2/3 of the body supported the wisdom of this view, less than a third opposed it. Now, for their part, opponents of birthright citizenship will say, you know, look, even if we accept all that, the citizenship clause was simply adopted during a very different era. Back then, we basically had a national policy of unrestricted immigration. Right? There were specific categories of restrictions. No, I'm trying to remember, no convicted criminals, no prostitutes. We had laws against the importation of slaves. But you know, to be fair, that was pretty much it. There was a pretty unrestricted environment, very different from our current immigration system, where the presumption is the opposite, if you will. You now have to have a legal basis to come in, as opposed to presumption that you can come in. So one could argue, you know, don't modern times call for modern solutions, where you know all the statistics we just heard about the cost of illegal immigration, maybe that should drive a difference in the rule. But of course, most conservatives are originalists. Originalists who abhor notions of a living, breathing, evolving constitution whose meaning changes with the times. According to originalists, if you have a rule that's articulated in 1866 and it's codified in the Constitution accordingly, that rule must remain the same today. So in short, if you are born in the United States and you're not immune from U.S. law, you should have a constitutional right to citizenship, and that should be true whether you're born in 1911 or 2011. Finally, opponents of birthright citizenship frequently resort to the fact, and I think we just heard this, that a lot of foreign countries don't like this rule. And that's true. In fact, there are a lot of foreign countries that used to have this rule and have specifically abrogated it. Gone the other way. They used to have our rule, or at least what I say is our rule, and now they've specifically rejected it. All that's true. Some countries still have it, but a lot of countries do not. But of course, most conservatives also abhor the notion. I'm sorry, let me rephrase. Most conservatives believe that America is unique amongst the community of nations. The term American exceptionalism is something that most conservatives rally around. Conservatives also typically abhor the notion that we would look to foreign law to define the meaning of our unique Constitution. So given these values, I'll wrap up here. Okay, I'll wrap up here. Given these values of textualism, originalism, and American exceptionalism, we shouldn't be surprised then to learn that, for example, birthright citizenship was supported by the Reagan administration, as well as all 9 justices on the U.S. Supreme Court that decided the case of Tyler versus Doe, including then Justice William Rehnquist. Hans, I think, laid out the Supreme Court history, so I don't want to go through that again, but I'll note just this one point. As he noted, the court looked at this issue in the Wong Kim Ark case. The majority said that the citizenship clause does cover the treatment of this lawful permanent residence in that case. I think that the typical response from my friends on the other side is, but it's only about lawful permanent residence. It shouldn't go after, it shouldn't be read broadly to cover, for example, the undocumented population. The problem with that is the case of Plyler versus Doe. In Plyler, the majority specifically extended the Wong-Kim-Ark analysis to undocumented persons, and did so with the express support of the dissenting justices in that case, as well as the Reagan administration. I don't want to take up too much time. The case involved equal protection. I can talk about that maybe during Q&A if people are interested. But I'll just quote here the court's words. No plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful versus resident aliens whose entry was unlawful. The last thing I'll say is just to address this issue of consent and feudalism and those sorts of issues. I confess, much of what I've talked about is sort of typical lawyerly discussion. Legislative history, text, precedent, that's what lawyers like to talk about and what we litigate over. I've never, so that at least understand, even if we can disagree, I understand that's a standard discussion. I've never understood this sort of invocation of consent or the invocation of feudalism. Consent of the governed is absolutely a basic American principle. But of course, the whole debate here is, what did we consent to? I mean, I understand that people may disagree with my view of the 14th Amendment, but if my view is correct, then we consented to it. We had a debate in Congress, we had ratification debates in the states, we consented to it. So if my interpretation is correct, then obviously we have simultaneously satisfied the consent principle. Finally, with respect to feudalism, absolutely true that we're not a feudal country, that we rejected those notions. But I think Hans has already laid it out. What we rejected was the notion that once a citizen, always a citizen. This notion that you could never escape British control. The notion that, frankly, if you're a British subject, you're a subject. In the United States, you're a citizen. All that's absolutely true. The issue there is a discussion of exit rights, essentially, right? It's the idea that you can't escape British control. That's not an American principle. It's also not what we're talking about with regard to birthright citizenship. Make no mistake, we have a right of renunciation. And if you are a 14th Amendment protected citizen, whether your parents are illegal or came across on a Mayflower, no matter who you are, that very day you can renounce, you can leave. And so I've never understood how the feudalism issue affects this discussion. Did that?
Before we go to questions, we have a 5-minute response from Hans.
Well, it won't take 5 minutes. I'll just make a couple points. First of all, Jim mentioned this other equal protection case, but that was a case involving people protection of the law. The Supreme Court has never issued a decision saying that individuals who are born here of parents who are here illegally are United States citizens. That has not been decided. Second, Jim says subject to the jurisdiction thereof is simply another word for power, being subject to the power of the federal government, and the way I've interpreted it. Well, then again, Indian tribes don't help him with that view. Why? Because tribal governments are fully within the power of the federal government. Okay? They only have very limited sovereignty. The United States government, the federal government, Congress, they have full civil and military authority over Indian tribes. I mean, for example, if an Indian tribe on a reservation out west decided that, well, we're not subject to the power of the federal government, we can raise our own army, and that would not happen because they are subject to the authority of the federal government. So if it's just a matter of power, then obviously his argument doesn't work, because Indians and Indian tribes were subject to the power of the federal government, and there would have been no reason to say that they could not be United States citizens. In the Wong-Kim-Ark case, which he had a reference, the 1898 case, the dissent written by the Chief Justice of the United States, and I'm just going to quickly say what he said, because I disagree with him on an interpretation of legislative history and discussions over the 14th Amendment. But the Chief Justice said in his dissent that the concept of birthright citizenship was rejected by the principles of the American Revolution and the framers of the 14th Amendment. That the whole concept of the 14th Amendment came down to you would only be a citizen if you owed complete allegiance to the United States, and that simply does not apply to people who were born here of illegal aliens who, when they are born, are citizens of wherever their parents came from. Thank you.
So Barack Obama is a British subject.
So much.
Do you have a response?
I'm fine with those pretty much.
Okay. Any take questions from the board?
Anybody have questions? Mary?
We both have difficult answers.
And cited some cases
Can you say a little louder? We can't hear you.
He had cited some cases, and one of them referred to a resident alien. And I'm wondering, is there a difference between a resident alien and an illegal?
Well, the case I cited, Plyler versus Doe, dealt with that exact issue. And maybe this will be my opportunity to respond to the rebuttal. Plyler versus Doe was not a citizenship clause case. It was about a different part of the Amendment, not the Equal Protection Clause. But what's interesting is the Equal Protection Clause has the same type of language. The Equal Protection Clause does not apply to everybody. It applies to only those persons who are within the jurisdiction of the United States. What Plyler was about was a Texas law that said we're going to give free public education to everybody, all children, except U.S.-born, except the undocumented population, except illegal aliens. And that was the issue, is whether that violated the Equal Protection Clause. The court held 5-4 that it violated the Equal Protection Clause. But the court was 9-0. They actually all agreed with the proposition that the Equal Protection Clause applies to illegal aliens. The only disagreement was, does the government of Texas have a sufficient government interest to overcome the Equal Protection objection? So, in the course of deciding the first question, does the Equal Protection Clause even apply to the illegal population? The court said, let's look at Wong Tamar, which uses this jurisdiction analysis, the same language in the 14th Amendment from a different clause. And as Hans noted, Wong Tamar is only about, it only deals with legal residents. But the court specifically says, and I'll just probably use to repeat the quote, there's, in the court's words, no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry was lawful and those whose entry was unlawful. And I think the reason is very simple. What's jurisdiction? Jurisdiction is power. Whether you're a lawful permanent resident, a tourist, or an illegal alien, all three categories of individuals are subject to U.S. power. You have to follow U.S. laws. In fact, you could say that the very reason you are an illegal alien is precisely because U.S. law applies to you. By contrast, if you're a diplomat, I guess we just had this issue with the IMF person, a diplomat coming here to the United States can commit murder, can commit rape, and cannot be prosecuted because they enjoy diplomatic immunity. Likewise, there's combatant immunity. We send one of our soldiers to Iraq or to some foreign country to fight and kill on behalf of the United States government. Can they be prosecuted for murder in another country? I certainly hope not. And they can't, because the laws of war provide them immunity against the laws of that other country.
So the government treats an illegal alien and a resident alien as the same. So if you enter the country legally or illegally, your children are treated the same. That's your interpretation.
Yes, well, I guess what I'm saying is, given the nature of the 14th Amendment, what it says is it's a two-part test. You are guaranteed U.S. citizenship if you are, one, born in the United States, and two, subject to the jurisdiction of that army. What does that mean? It means if you're subject to the power of the United States, you don't have immunity against the United States.
Would a child be subject to the power of the United States if their parents have allegiance to another country?
Sure. In fact, the parents themselves are subject to the power of the United States. If you're a foreign citizen, you come here not as a diplomat or a lawful combatant, you just come as anybody. You're a lawful permanent resident. You have to follow U.S. law. You can't commit murder, nor can you violate our traffic laws.
I have a follow-up question.
Right.
Mr. Hope, just following what you just said, is it your position that just physical presence in the United States of America of an illegal alien is deemed to be allegiance to the United States of America? I find that very strange, because you see, most of the illegal people that I'm aware of apparently are economic refugees. They don't care about America. They care about getting a job. Well, that's not to be equated with allegiance. I can tell you one thing, just as you're saying, but it seems to me that
you're attacking something that's not been said.
But that may well be, but I'm kind of wondering, are you giving a legalistic, the one problem I have with perhaps both of your presentations is that both of you speak in terms of the person coming to America, but I really don't see any connection that that person who comes to America has with the United States, aside from physical presence.
Okay.
Do you understand what I'm saying?
I think I do. Nobody has said.
Please go ahead.
Nobody has said, and I certainly have not said, that every single person who comes here has allegiance to the United States. Nobody's ever said that. I certainly have not said. I'm sure Hans didn't say that.
Isn't that a requirement for citizenship, though?
That's the debate. Oh, for citizenship.
Yes.
It depends on what rule we're following. I mean, naturalization certainly requires allegiance, or at least that's my understanding of most of the immigration laws now today. But we're not talking about the INA. We're talking about the 14th Amendment. What the 14th Amendment says is being subject to jurisdiction.
But the 14th Amendment says being subject to the, now in this case, I kind of find Hans's statement a little bit more compelling in that if you're coming into America and you don't have any real connection to America, you still are a subject or citizen of the foreign country. Even if you're running away from it, you're still subject to them.
I think we would all agree that the immigration laws of our country are full of weird quirks, weird doctrines, weird quotas, weird exceptions. I think that's the very point that I'm trying to make, actually, is that as lawyers, and particularly as Federalist members, we separate legal interpretation from policy. There may be lots of ridiculous rules on the books, but the proper remedy is to change those laws through the administrative process, through Congress, or through constitutional amendment, whatever the case may be.
By the way, which process would you recommend to change this law, presuming that you would like to change it? Constitutionally or legally?
Constitutional amendment, absolutely.
But not a law.
If this is, no, that's the whole point. The whole point of the debate is whether or not we can go by statute, obviously.
You say no.
And let me respond to your point. I fully respect your policy views. I truly do. Frankly, if I thought I might very well agree with you. The point here, though, is not a policy debate. What I would say is this. The views that you've described are actually quite similar to the views that were debated during this discussion. They sound very similar to Senator Cohen. My point is, they were debated, and that side lost. We might regret that. I'm sure we've read lots of things that are going on in Washington right now. How do you undo them? If it's a constitutional amendment, the only way to undo it is another constitutional amendment. And I should stop.
By the way, Mr. Ho, I have been an admirer of you for a long time, and you have not disappointed me.
Thank you very much.
Despite the fact we disagree with each other.
Any other questions? Does equal protection apply to illegal
aliens who violate the law in terms of crossing the border or overstaying visas or some other illegal way?
I want to make sure to divide. There are two different issues actually in your question. Whether the Equal Protection Clause applies and whether it's been violated. Two very different questions. There's actually no debate. I mean, all 9 justices in Pilot v. Stowe agree that the Equal Protection Clause applies to illegal aliens.
They are, they can't be violated with equal protection, but it doesn't apply to them. It's something else.
It's not done. That's our entire legal system is based on this principle. Question number 1 is, does a particular provision apply to you? And then question number 2 is, has that provision been satisfied or violated? So I'm sorry, I'm not really sure. I'm sure you agree with that, right?
Yeah, but the answer is
it's pretty straightforward.
That equal protection applies, but it may be severely limited. And the example I'll give you is the fact that when Congress passed a law saying that illegal aliens would no longer get welfare benefits, I think there were lawsuits filed saying it's violated equal protection, and the courts said, doesn't violate equal protection, you're here legally, you're not entitled to these benefits.
Let me, if I could maybe help in this regard. Yelling fire in a crowded theater. Okay. Is there a First Amendment interest in yelling fire in a crowded theater? There is. There emphatically is. That's speech.
What if there's a fire?
That's speech. It doesn't matter. Work with me on this. You have a speech interest in yelling fire in a crowded theater. So the First Amendment applies to that. It's a separate point. Once you've decided that the First Amendment applies, then you have to ask if it's been violated. Or does the government have a sufficient interest in overcoming your right? And the notion there is, yes, we do, because it hurts people, et cetera, et cetera. So there's compelling interest. That's the whole point of constitutional scrutiny, or all sorts of criminal scrutiny. The only point here is, I just want to answer your question, is equal protection emphatically applies to the illegal population. I honestly, I don't know if anybody would disagree with that. The only question is, what policies that classify, that discriminate against illegal aliens are nevertheless valid. Obviously, our entire immigration system is premised on the fact that you're allowed to kick out illegal, and that's okay. Exactly. Although I'm not even sure it's strict scrutiny, that's another debate altogether. I'm guessing it's a lower level scrutiny.
Someone from this side.
You're going to answer some patent question, right? So
No. You make a compelling argument, but if and only if your definition of jurisdiction equals power, which equals not subject to or not immune from the laws of the United States. At least that's what I got from, somehow you leapfrog. You leapfrog all the way into that jurisdiction equals not being immune to the laws of the United States. And I don't, somehow there's a disconnect there, at least in my mind. And I don't quite understand how immunity from the laws of the United States, or non-immunity from the laws of the United States equals jurisdiction.
Let me try a different idea on you, and if it doesn't work, it doesn't work. If we were to say that the FCC has jurisdiction over Howard Stern, what would we mean by that? I don't think we would mean that Howard Stern has pled allegiance to the FCC. I don't think it would mean that Howard Stern has a great track record of complying with the orders of the FCC. All we're saying when we say that the FCC has jurisdiction over Howard Stern is that the FCC has power over Howard Stern. That if they issue an order, it binds Howard Stern, and if he violates it, the FCC can go to court and enforce that order against him. That's all that jurisdiction means. Jurisdiction means power.
Anyone else?
Okay. Wait, how does that relate to non-immunity, though?
Well, I guess my point is, what does it mean to not be subject to the power of something? When it comes to the power of the United States writ large, we're all subject to the power of the United States unless we have some sort of legal immunity. Diplomats have immunity against them, and that's expressly what the debaters of the citizenship laws talked about. Everybody agreed that diplomats were not covered. And it's precisely because of the notion of immunity, meaning that you're not subject to the jurisdiction of the United States.
People have left the country. You kind of love the United States.
You're talking about in terms of like extraterritorial. That extraterritoriality is sort of a whole different legal discussion. It doesn't really apply here because the 14th Amendment only applies if you're born or naturalized in the United States. So we're not worried about that.
That brings up a whole other argument, of course, we're not going to get into, which is what is
subject matter versus
what is a natural born citizen of the United States? That's what you have to be to run for president. And that's another interesting. That's another interesting question that really hasn't been litigated and been really no decision.
If you want to change the natural born citizen laws, you need a constitutional amendment. Yeah. That's really the only point that I'm trying to make here is if you don't like birthright citizenship for any number of the policy reasons we've discussed, we absolutely can change it. Absolutely. It's the same constitutional amendment process that you need to get rid of natural born citizenship.
Your argument was that a constitutional amendment is not necessary, that you can basically deny birthright citizenship to legal aliens without basically doing anything.
Yeah, because I think that phrase has been misinterpreted by the courts and frankly by the State Department. Because the State Department will issue you a passport if you just show them a birth certificate. That's done by basically executive fiat. It's not done because I don't think it's required.
So your position is nothing has to be done. We just have to reinterpret the amendment, the clause.
Yeah, I think if Congress, for example, passed a law telling the State Department it could no longer issue passports to individuals who were born in the United States unless they could show that at least one of their parents is a U.S. citizen. I think they can do that because I think that's allowed under
I'm just going to ask a quick question. Do you know, is there any case on its way up the ladder now that deals with this issue?
I'm not aware of one.
There isn't, because basically the way this is being teed up is somebody has to pass a statute.
Yeah.
Right? And presumably it's Congress. We didn't talk about the state stuff. That's a whole other issue. But somebody has to pass something, and then that almost certainly will trigger the issue.
But Hans, I know you have to go, and you don't want to be
I apologize.
having a heart attack getting to
I
the train.
have to get back to Washington tonight because I got a meeting in the morning I can't miss, so I apologize.
So I ask everyone to give both of them.